Can my boss demote me without a valid reason? Imagine this. You've worked at the same company for years, putting in long hours, taking on extra responsibilities, and even training new hires. One morning, your manager calls you into the office and says, "We're moving you back down to a lower position." No warning, no explanation, just a demotion. Suddenly, your pay, your status, and your career path are all on the line. Naturally, the question is, can my boss legally demote me without a valid reason? For many American workers, this is a painful reality. A demotion can feel like punishment, a way to push you out, or simply unfair treatment. The law around demotions is complicated. In an at-will employment system, employers often have broad discretion, but there are limits. Demotions tied to discrimination, retaliation, or violations of contracts can be illegal. In this video, we'll break down when demotions are legal, when they're not, and what you can do if you're unfairly pushed down the ladder. At-will employment. The general rule. Most workers in the U.S. are employed under the doctrine of at-will employment. This means your employer can change the terms of your job, including your position, title, or pay, at almost any time, for almost any reason, or even for no stated reason at all. That includes demotions. Example: a retail worker is demoted from assistant manager to cashier because the employer wants to cut costs. Under at-will employment, that's legal as long as it's not discriminatory or retaliatory. At-will also means you can quit your job at any time, with or without reason. But the imbalance of power means workers are often the ones harmed by sudden changes. When demotions cross the legal line. Even in an at-will system, employers cannot demote workers for unlawful reasons. Federal and state laws create boundaries. Discrimination. Under Title VII of the Civil Rights Act, employers cannot demote workers based on race, color, religion, sex, or national origin. Disability. The ADA prohibits demotions motivated by disability or failure to provide reasonable accommodation. Age. The ADEA protects workers over 40 from age-based demotions. Pregnancy. Demoting someone because of pregnancy or childbirth-related needs violates the Pregnant Workers Fairness Act. Retaliation. Employers cannot demote workers for asserting legal rights, like reporting harassment, filing a wage complaint, or taking leave under the FMLA example. A warehouse worker complains to OSHA about unsafe conditions. The next week, she's demoted. That's retaliation and unlawful. Contracts and collective bargaining agreements. Some employees are not purely at will. If you have an employment contract or are covered by a collective bargaining agreement through a union, your employer may need just cause to demote you. Example: a teacher under a union contract can only be demoted for documented performance issues. If the school district tries to demote them without justification, the union can challenge it in arbitration. Contracts often spell out disciplinary procedures, progressive discipline steps, or rights to appeal demotions. If these are ignored, the employer may be in breach. Wage and hour implications. Demotions often mean pay cuts. Employers can legally reduce pay with a demotion, but they must follow rules. Pay can never fall below federal or state minimum wage. Exempt employees who lose their exemption status may need to start receiving overtime pay under the FLSA. Pay changes cannot be retroactive. They apply only moving forward. Example: an employee earning $20 hour is demoted to $15 hour. That's legal as long as minimum wage is respected and the change is communicated in advance. Demotions as constructive discharge. Sometimes a demotion is so severe it feels like the employer is trying to force you to quit. This is called constructive discharge. Courts may treat it as if you were fired. Example: An executive is demoted to an entry-level role with a 60% pay cut, no office, and humiliating duties. If the demotion was intended to make the employee resign, it may qualify as constructive discharge, opening the door to wrongful termination claims. Real-world cases. Case 1. A woman in her 50s was demoted while younger, less experienced co-workers were promoted. She sued under the ADEA and won damages for age discrimination. Case 2. An employee who requested disability accommodation was demoted instead of accommodated. The court ruled the demotion violated the ADA. Case 3. A retail worker who reported sexual harassment was demoted to part-time. The EEOC found retaliation and ordered remedies. Case 4. A unionized worker demoted without following progressive discipline steps successfully challenged the demotion through arbitration. These cases show that while demotions are legal in many situations, unlawful motives can change everything. State laws offering extra protection. Some states go further than federal law. California. Strong anti-retaliation laws and protections for whistleblowers make unfair demotions easier to challenge. New York. State human rights law covers more categories, including marital status and sexual orientation. Massachusetts. Protects workers from retaliation if they assert wage rights or participate in investigations. Example. A California employee demoted after discussing pay with coworkers may claim retaliation under both state labor code and the NLRA practical steps for workers facing demotion. If you've been demoted, here's what you can do. 1. Ask for a reason in writing. Even if not legally required, this can reveal unlawful motives. 2. Review contracts and policies. If a handbook or contract sets discipline rules, employers must follow them. 3. Document everything. Keep notes of conversations, dates, and any evidence of retaliation or discrimination. 4. Check pay compliance. Make sure new pay respects minimum wage and overtime rules. 5. File a complaint if necessary. The EEOC, OSHA, or state labor boards may help. 6. Seek legal advice. Employment lawyers can identify if a demotion is actually unlawful. Example. A nurse demoted after taking FMLA leave documents. Emails suggesting the leave caused the demotion. She files an FMLA retaliation claim and wins reinstatement. The human impact of demotions. Demotions don't just cut pay, they cut dignity. Workers often feel humiliated, sidelined, or punished. For many, a demotion is worse than being fired because it forces them to stay in a job under degraded conditions. The law recognizes that when demotions cross into retaliation or discrimination, they can be as harmful as termination. Example. A father demoted to part-time after requesting flexible hours to care for a child faces not only lost income, but stigma in the workplace. The bigger picture. The balance of power in at-will employment often favors employers. But laws like Title VII, the ADA, the ADEA, and the FMLA provide guardrails. Contracts and unions strengthen those protections. Workers who know their rights can distinguish between a legal business decision and an unlawful demotion. So, can your boss demote you without a valid reason? Under at-will employment, yes, demotions can happen suddenly without explanation. But there are critical limits. Demotions based on discrimination, retaliation, or violations of contracts are unlawful. Pay cuts must still respect wage laws, and extreme demotions may amount to constructive discharge. The bottom line, not every unfair demotion is illegal, but many are. Knowing your rights under federal and state laws helps you spot when a line has been crossed. If this video helped clarify your protections, share it with coworkers. Demotions can feel isolating, but you're not powerless. The law provides tools to fight back when a demotion is used as punishment instead of fair business practice.